What were they asked? What did the complainant, aka the victim, of the alleged crime get asked when they were questioned during the hearing at the New South Wales Local Court? I'm observing the type of questions complainants get asked. Not the answers, just the questions. Why am I talking about this? Just to speak more openly about what people who are victims of crime get asked in court. It's not why they get asked, just what they get asked. And what does the court allow them to be asked? Disclaimer, these are just my observations. The questions that I heard, there could be mistakes in the wording. However, my intention is to give a general feel of what questions got asked and what questions the court allowed. And no real names are given to avoid defamation and privacy. I will include a couple of details about the case just for general context. This case is from here at Raymond Terrace Local Court. The hearing was in September 2024, which was about 18 months after the alleged offence occurred at Nelson Bay. Mr. Complainant alleges that Mr. Defendant attacked him. Both men are probably in their 60s and they are neighbours. The questioning occurs in an open court. And on this day, the gallery is fairly packed. There are about 5 journalists in the gallery and 2 cameramen waiting outside. I can't find any media stories about this case. By the way, they're here for another case. I'm just letting you know who was in the gallery because the complainant had an audience when they were questioned. I also want to acknowledge that there's probably 4 or 5 sides to this story. So that's another reason why I won't say the answers, to avoid telling a one-sided story. What was the complainant asked? The first question they asked is, do you want to swear to God or swear to the court? Yes, there are formalities first. Let's skip to the questions about the alleged offence. The prosecutor questions first because the complainant is the prosecutor's witness. Remember, the prosecution has the burden of proof. They need to prove the elements of the offence beyond reasonable doubt. So the prosecutor asks the complainant to tell the court what happened. It's a series of open questions. What happened then? How many times were you hit? Were you struck in any other way? After the complainant answers, the prosecution might ask a follow-up clarifying question. You said you were hit in the head. Can you show me where on your head? What happened next? How far did you push him? It's a series of questions that prompt the complainant to tell his version of events. Then the complainant is asked to draw the scene, and there's a bit of back and forth asking to mark particular points like where did he fall. So in between questions there may be some drawing. To be clear, I don't think the prosecutor is leading the complainant or pressuring them to answer in a certain way. That's just my observations. The complainant is shown photos of the scene and photos of his body. We can't see these photos in the gallery. He is asked to describe what is in the photo. Is there anything you recognise in the photo? What can you say about that? So prompting to tell the story, but not suggesting what the answer should be. Next is the cross-examination, where the defence solicitor or barrister asks the complainant questions and adds their evidence. It starts with a series of clarifying questions. By the way, the questioning is delivered a little faster here than we saw when the prosecutor asked the open questions. How did you get back from the street to the garage? You described to O it was a baton. Do you stand by that? Do you remember telling them it was a bat? The police have your medical records. Can you read to yourself page blah, 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 blah? So the complainant reads some documents. Then is asked, does that refresh your memory? By the way, between these questions is the answers. Do you remember saying to O it was a baseball bat? Do you recall saying baseball bat 5 times? It is a solid item. You were struck in the head. You were struck in the face full force. Lots of closed questions producing yes/no type answers. And again, it's at a faster pace. Do you accept? There were x-rays. Do you accept that that doesn't support that you said 26? Then the questioning starts to change because the more statements are being said. What I mean is they aren't actually questions. I suggest you have exaggerated what happened. I proposed a situation to you, blah, blah, blah. I suggest you stood up and pushed. I suggest Mr. Defendant pushed back. At no time was Mr. Defendant armed with a bat. No time did he strike you 26 times. No time did he chase to the pool table. On your version, when you were out of the garage door, and then blah, 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 blah. At no time did he drag. By the way, the complainant is responding between these questions/statements. I suggest Mr. Defendant made no threats. The questions stop and the court is shown a short, very blurry video. And then the questions start again. I suggest it was a stick. I suggest you were armed with a stick. I suggest you followed him and attacked him. I suggest you struck Mr. Defendant with the stick. Have you heard the saying, stage the scene? I suggest you stage the scene. The court, including the gallery, are shown the body-worn video from police who responded to the 000 call. It goes on for a while and it shows the complainant interacting with the police. Then back to questioning. Do you remember saying that the garage doors were down? Then the court is played the 000 call. Do you recognise that voice? That's your voice. Do you recall the door being up? That the doors were open, so it looks more dramatic when the police arrive. So the complainant is being asked questions that clarify his version of events, and the court is allowing the complainant to be asked these types of questions. So you'll notice that there's a couple of statements mixed in there between the questions. In my opinion, they are not a disallowable question. Yes, you might find them annoying or repetitive, but they have to be unduly annoying to be considered a disallowable question. Remember, the magistrate is sitting right there, and they are the person the prosecution and the defence are trying to persuade. The magistrate will be the person who decides if the elements of the offence have or have not been proven beyond reasonable doubt. This leads me to an observation about this example. I think a complainant in a situation like this should just focus on telling their version of events. Let the prosecution and the defence worry about the elements of the offence. It shouldn't matter what style of questioning the prosecutor or the defence use on that day if you just stick to telling your version of events.